Hey, everybody. Welcome to week 214. Yes, it's week 214, and it's dealer's choice. So we had to mix it up and we had to improvise. So that's what we're going to do today. You guys know the drill. Hit us up on the chat if you want to harass us. We can take it. And if you want a bona fide question, use the Q&A, and I'll be monitoring all of that. So I know that Jack Santinello had something that he wanted to dive into early. So if you want, Jack, you're the ace of hearts. Go
Wait,
for it.
wait, wait. I thought it was the Jack of Hearts. What? You got to find that card.
I'll find it's right here.
Okay, there. That's better. All right.
All right. Yeah,
So,
you are the Jack of hearts. I like that.
oh my gosh, how many seconds did it take? That's okay. See, that wasn't even a dad joke. I guess it could have been. Maybe that's why you were filtering it out, kind of thing.
Yeah. So Adam will be the A, so that's what we'll do. When we
Okay.
pick up
I,
an ace, then
no,
we'll go
I,
out.
I was gonna say I kind of feel like the two of spades right now. It's like basically freaking worthless and good for nothing.
No, that's not true. Not true.
Oh, Gary, dare I say, do you mean Adam after that debate last week?
Oh man,
Oh,
just deflated.
Sorry. It's just we were talking about just before Gary went live about that and that how all of us are going to go crazy if the conversation turns to any of that. So we're going to try to avoid having any conversation about politics and about any of that stuff that went on in the recent past 7 days or so. So focusing on this, what everybody is calling the post Chevron era. So, and I touched on this previously, but there is a case that the Supreme Court they're holding. And so let me give you a little bit of background. And so, and I'm reading from Lexology report. So it says, after nearly 40 years and more than 1,800 judicial opinions in which it was applied, the Chevron doctrine was overturned, and then held that the statute of limitations to challenge an agency action does not begin to run until a plaintiff is actually injured. And so what does this mean essentially? And I will again read to you, but then I'll share my thoughts on that. So courts must exercise their independent judgment in deciding whether an agency has acted within statutory authority and may not defer to an agency interpretation of the law simply because a statute is ambiguous. Courts can consider the interpretations and opinions of the agency and should accord due respect for the specialized expertise and informed judgment of the agency. However, the weight of those interpretations will depend on the thoroughness evident in the consideration, the validity of its reasoning, its consistency with earlier and later pronouncements, and all of those factors which give it the power to persuade, if lacking power to control. Prior cases holding that specific agency actions are lawful are still subject to statutory challenges despite that holding. So let's talk outside of lawyer speak and what all that means.
yeah.
So
What does that mean?
exactly. So, prior to this, and it makes sense. So recall that when Congress passes a law and it gets all the way through the congressional process and the president signs it or it gets vetoed and then it gets overridden, that it's even though a lot of those statutes are very voluminous, they don't get down into the nitty gritty, into the weeds that is required and necessary to properly implement what that new law says or the modification to the law. So then you have the agencies, the regulatory administrative agencies, that, and we've talked about them before, whether it is the US Treasury, the IRS, and others that are given powers to interpret and fill in the gaps in between the provisions of the statute. And this happens across the board. So, for example, in the context of franchise, there is this federal rule, and then states will go and they will interpret what that rule means within that framework, and they're not allowed to exceed that. in most cases. And so what happens here is that they're saying in this court case that the deference to the regulatory agency, the EPA, the FDA, the IRS.
Yeah, I was gonna pick up on, like, that's a big freaking deal.
Yes, absolutely. So what they're saying is that we will we will give a little bit of deference, but it's not absolute in that the power now resides in the courts to say whether or not this is appropriate and this is okay to be implemented. So the agencies, as far as I understand, are still required to put together this framework. But when the agencies had the ability to say, and we mean it, and this is the law. The regulation is the implementation of the statute, and you have to comply with that. And of course, you have challenges to the implementation of that. But now they're taking a step back and saying, okay, now the actual framework that is put together, the court can review that. And so, what that creates is just a lot more administrative bottleneck. I understand the reason being is that, okay, well, if you're the one that's making the rules and you're pretty much the absolute judge of whether the rules are okay, that's kind of, not a good
Yeah.
thing. There should be someone else that is reviewing that. But and they said the right things that they should have, which is, okay, yeah, we're going to give deference to the agencies because they have the relevant expertise. Most congressional members are not, or most judicial members, meaning judges, are not scientists. They don't, so they don't have the expertise, the scientific expertise, or the financial expertise, or all and to understand how that when they implement something, how it works through the system as far as taxation and all these other things and loopholes in the IRS code. So it'll be interesting to see how now, because what happens is the Supreme Court says this and then it has to be implemented down below. So it isn't the end of the story necessarily, but I think it's going to hamper regulatory agencies that are doing a good job and doing a fair job. It will impact those agencies that have traditionally been bullies and saying it's our way or the highway, and you can't do anything about it because we know that you do not have the ability to challenge this at the level that it needs to be challenged. So those are my interpretations of kind of where the current status of all that is.
So it basically throws a checkpoint for a rogue agency that wants to bully and go outside or define their own thing. Is that correct?
Yeah, and it isn't that it's giving the ordinary person, the
Yeah.
ability to now challenge the stuff. It is basically, it would be maybe, for example, the pharmaceutical industry, that the FDA comes down and promulgates something, and then the industry gets together and says, okay, now we're going to challenge it, not challenge the implementation of it, but challenge the legitimacy of the actual rule, not the implementation of the rule. So that's kind of the differentiation. I mean, it's more complex than that, but that's kind of the differentiation of and why this is so important.
Yeah, and
Interesting.
from the IRS perspective, there's really, if you kind of go back to what Jack was saying, um, about, hey, when there's something silent or vague in a law, so the upside of that is that there is a lot of stuff in the tax code that is subject to interpretation or silent or vague. On the other side of that, though, there is a lot of times in tax law where it says, hey, here's the law, and we're going to leave it to the Department of the Treasury to go ahead and write the regulations around this. So, point being that, hey, you know, is it all of a sudden, hey, game on? Probably not when it comes to the IRS. But I do expect that there is going to be a lot more favorable tax outcomes, for challenges. And the reason that I say that is because if you just look at the overall body of tax court cases, when it's something that is ambiguous or subjective in nature, the tax courts generally side with the taxpayer. Like they don't give them 100% of what they're asking for, but they generally side with the taxpayer and not the Department of Treasury. So, like what a classic example would be, a valuation discount case in an estate. You know, they're I may argue that, Jack, your multi-million-dollar business is worth $1, and the IRS says, no, it's worth $500 million. I'm not going to win my dollar, but Jack's not going to come close to, or sorry, the IRS is not going to come close to getting the $500 million argument. They'll probably land at 15% my way. Sorry, more 15%, like bring me up about 15%, negate about 85% of what the IRS wants. If you just kind of look at the history of what the settlements are. So from that standpoint, I think that's interesting. I think, my own feeling, about everything else is like, yeah, I get where they're coming from. At the same time, it's like, it's not like our courts have a good history of actually getting through stuff timely. So as a business owner at the same time, it's like, yay, more uncertainty.
Yeah, the courts are getting through their backlog from COVID, but I mean it's still just a mess. They've done some things to make things a little easier, meaning that okay, the video depositions when you're not all in the same room. I will tell you that as in representing defendants in civil actions, I don't, but my colleagues do. They would never allow a trial to actually occur via video. You have to be in person. You have to be facing your jurors. And so, it creates a larger mess, and our judicial system doesn't have the capacity to deal with it, I don't think. And a lot of people don't think that has the capacity. And so, it's just one of those things that happens routinely, that somebody comes up with a great idea in the interest of public policy and in public interest, but doesn't really address the ramifications and the waves that ripple effect that happens when you make a decision like that and the impact on other resources. It's like, okay, well, we fix this problem, we'll fix that problem as it occurs. Well, then you have people that are waiting legitimately for their cases to be adjudicated on more important issues that are getting pushed back because dealing with things like this. So, and again, not to minimize the importance of issues like this, because usually if there's a challenge to a regulatory regime, it's pretty big and important, but many times it doesn't affect the little people.
So Matt has got a question for you, Adam. With respect to the IRS as one agency, is it your impression that they're adequately staffed? Can your teams always get through to them?
Oh no, it's terrible. It's not that crap's not got any better. It's still complete. It's still complete hit or miss. And I mean, there was actually an article on our trade, one of our trade magazines that just talked about, okay, so they're starting to ramp up because they never cut that whole, the whole, we're going to defund the IRS thing. That still is intact, the funding is still intact. So they have hired a couple people, but it's the feedback is these people suck. They're just not helpful. They're not resolving issues. So that actually hasn't been my experience thus far. My experience thus far has been sometimes I get through, Sometimes I'm on hold forever. And then sometimes like they're so busy that the literal, and remember, I have like a secret bat hotline that I get a call, the practitioner priority hotline. And sometimes you call and it literally just says, we're so busy, call back later, click. I mean, like, what am I supposed to do with that? And what sucks about it is, clients kind of freak out and panic about the fact they have a notice, me explaining, hey, it's probably gonna be okay. It doesn't really help. They want to know that I called, they believe it's possible to multitask while you're on hold with the IRS. And the answer is ish. You're still tied, at the phone, so meaning sure I can multitask, but I can't take another phone call. I can't start another meeting. So it's basically, I don't know what time this is a tirade, Jack, but like, do I need to budget 2 hours, or 30 minutes, because I don't know about you guys, but like, I don't actually have 2 hour open blocks of time
Yeah.
to make a phone call and sit on hold. I kind of have meetings most days. So it sucks.
Yeah,
What's the
one of my,
longest?
like I say,
Go
one of our
ahead.
corporate paralegals is very good about multitasking by doing, but she knows, okay, I get focused on the phone line that's on hold, and we'll be with you shortly. We'll be with you, whatever the recording is. But yeah, doing it because I can hear it through her door when I walk down the hallway to go get a drink of water. So yes, it is pop. But yeah, she has to, and I can see the expression on her face every time. I'm like, yeah, we need to call the IRS, meaning you need to call the IRS, and she's like, okay, I'll do it. But yes.
What's the longest that you've been on hold, either one of you, with the IRS? I'm just curious.
You
It's a couple
know,
hours.
yeah, I haven't done it personally, but yeah, it seems like a time warp, and you're like, surely it hasn't been that long, but yeah, it has been that long that I've heard the recording go by, because usually when I go get water, I'm going to the bathroom, and so I'm not going to the bathroom every 5 minutes. It's been, there's distance of time between those events.
Well,
I
in
can't
all
believe I just shared that.
fairness, it's not just the IRS. It isn't like government. Let's just call a spade a spade. It's terrible. However, Spectrum, when they ported my phone number that I'd had for a dozen years to somebody else because of a Spectrum employee problem, I mean, I've had like 3 and 4 hour waits multiple times but I was desperate. I finally I MacGyvered the email address of the CEO, and I had about 11 iterations. I got through. Within 24 hours, it was resolved. So it's not just in the public sector. I know we bash, government a lot, and it kind of deserves it, but private sector, it ain't much better sometimes. So
Yeah.
anyway, so Adam, I'm looking at the ace of spades. That's you, Adam.
Yeah. Yeah.
Dealer's choice, man. You get to riff on whatever you want to riff on right now.
Sure. It's just another bad one that's top of mind. I'm normally a pretty positive guy, Gary. Uh, the overtime rules, which if this is where, Jack, just make sure I don't get sued with all this, if you don't mind. I'm not going to say anything bad. I just want to make sure I didn't say anything wrong from a legal perspective. With respect to overtime, you have um, multiple things that you have to look at typically. The first is whether I am exempt or non-exempt, and that comes down to a job description standpoint. So exempt means I'm exempt from the Fair Labor Standards Act, which and non-exempt means that I'm not, and that's kind of independent of whether or not I'm an hourly employee or a salary employee. It's just that I'm either exempt from it or I'm not exempt from it. That usually comes down to the job description and the ability of people to make independent, decisions, that have some sort of discretionary control, supervise people, all that kind of stuff. So, generally your non-exempt positions are going to be like the receptionist, meaning like it's hard, like you might, well, Jack, she can order the office paper and pick what she wants there. It's like you're not going to really win that argument, I don't think. So it so you're really talking about when you're really talking about, overtime for this purpose and the rule that just passed, you're really looking at exempt employees. So these would be people that, generally you pay a salary to, and they have some discretionary authority to do their job, and you're like, your salary and you're exempt, you don't qualify for overtime. Well, actually they do, because there's a minimum level that you need to pay them, that if they're below that, then you need to pay them overtime. So basically what they didn't want to have happening is like, hey, your salary, and I'm going to work you, I'm basically going to Bob Cratchit you.
Yeah.
Jack's giving a gift card, on that one.
Bob Cratchit, man, I haven't heard that.
So there was like a minimum that you needed to pay him, but the thing about it is like the minimum was about $36,000 a year, and it's like, okay, that's not chump change, but at the same time, that's not egregious in terms of money. And you didn't, did you have to have, did you have to have people keeping track of time or not? It's tough, because it's kind of a weekly test that you're looking at. Well, they raised that up, from 36 grand to, effective now, like right now. If you're not doing this, you should be doing this, right now. That got raised from 36 grand a year to about $44,000 a year. So if you don't want to be keeping track of overtime on employees, then everybody that was considered exempt and below $44,000, you just gave them a raise. Like that's what you would have to do to solve for this problem.
Yeah.
Well, okay. That doesn't sound too bad. But effective 1/1/2025, $44,000 becomes $59,000. So if you just put that in context, unless you want to be in the business of tracking overtime, then, basically you could have somebody that's making, 40 grand a year that, okay, I got it. I can stomach going up to 44 to not have to implement all these timekeeping systems or record keeping or whatever. Well, 59, now we're starting to talk about a big deal. That's painful. Like if I just look at our business, I mean, granted, new hires have sort of caught up, but if you rolled back the clock 2 or 3 years ago, I mean, we didn't start people at that level. So it's like, what? That were degree people that were getting ready to start sitting for their CPA exam. So it is a big deal. And I mean, it gets, when you don't follow this rule, it gets pretty nasty in terms of the penalties associated with it. It's not like, I've never heard of a case where like the Department of Labor came in and said, let me look at your timekeeping system. What happens is, Gary sucks, so I can Gary. Gary is incensed and then finds out about, decides, this was discriminatory, like how dare they fire me? So he goes and he consults with the employment litigation attorney to file a wrongful termination suit. And the first thing they start looking at is, well, tell me more about the job, Gary. How are you getting paid? What were you getting paid? What was your job description? And now all of a sudden I'm getting crucified
Yeah. Yeah.
over the fact that I either misclassified him or alternatively, I didn't know, I didn't know that I needed to follow this rule. If you're with a payroll company, they've been pretty good about like regression testing and saying, hey, by the way, these are the people that are impacted. You need to fix this crap. Otherwise, we're not going to process your payroll. But if you're not, then and you're doing your own payroll, then you got a problem that you need to deal with. And there's no way out of this. Like I've never heard of a court challenge to something like this. I suppose Congress could actually get their act together and pass a rule that says, hey, we're going to make it not effective, for another year or two, as they've done before with like minimum wage tests and stuff like that. But it's not good. The only little bit of a loophole that exists in it is that you can count a bonus in the calculation. So even if you haven't been paying somebody the weekly amount that you're supposed to be paying them that would otherwise qualify them for overtime, you can calculate the bonus that they're probably going to get paid or have been paid in that number. However, it's only up to 10%. So like if someone has like a 25% bonus, like the crappy base, big bonus, you're toast. When it comes to this. So it's like I think this is one of those, Gary, where a lot of people, it's because when it's 44, I think in the BGW client base, it's like, yeah, we've got some people that are going to be impacted, but it's not that many. When it's 59, now all of a sudden you got quite a bit of the headcount that may have some issues associated with it. So this feels very much like one of those, don't want to put the head in the sand. Well, that thing got away yet? Nope. You need to get out of it.
Where is your little ducky thing that goes like
I do need to get the ducky thing. That'd be great. Ah, boom, ah.
Yeah.
Yeah, that's what types on my computer, Jack, so I can pretend that I'm actually working. When I'm working from home.
Yeah, you have a mouse mover too, right? That
Yeah,
makes
I
it
don't,
if you
yeah,
want. Yeah,
but I actually have a real mouse mover. Not one of those fake, software generated mouse movers. I go old school because that way they can't find out that I've installed the mouse mover.
Gosh, who was it that I was in a meeting with this week and they talked about some sort of a stat of how many work from home people in a company that they were consulting with had installed those electronic mouse movers to circumvent the the corporate watchdog. Oh, I know. It was a lunch with a guy that's a global VP of operations for Humongo company, and that's what they found after with COVID. Like, are you kidding me?
Yeah, no, we heard. I think someone told us a story about like the Zoom video of the.
It is a loop.
I mean, that's hysterical.
that is hysterical. I didn't know about the loop, but that
Yeah,
kind of makes sense.
that's the real deal.
Yeah, the same bird keeps flying by over here.
Right, right.
But
Right.
actually, that's become grounds for termination with cause or for cause
should be.
termination. That if you are required to work and you deceive, and basically you're defrauding the company, and that falls under that, purposeful behavior that is defrauding the company, it's termination without cause, uncurable. They don't have to warn you about it, kind of thing. But I also know more than a few people that have those implemented either electronically or they have the actual, as Adam said, old school, that you put your mouse on top of and then it moves it. It actually, I think it moves the sensor underneath. It doesn't actually move I don't know, but
Oh
Yeah.
my.
Yeah, and I think that the other thing too with the salary rules, I mean, something to think about too, that I mean, look, I'm not excited that we're actually having to do this at BGW, but we are. It's like, you know, our positions are for a body of work, and if you're falling behind on the body of work, you need to make up that body of work. However that happens, so like it does it on the positive side from an employer perspective, it sort of raises like, look, if I'm not paying, if someone went from $38,000 to now $59,000, I'm also going to apply probably a little bit higher level of scrutiny in terms of I paid you to get 100 things done and you only got 50. That's going to be a real problem. We're going to be working nights and weekends around here, to
Yeah.
get that done.
Yeah.
So it does kind of make you kind of reevaluate productivity.
And bring your
So
stapler.
And bring your stapler. Otherwise, the problem's going to sort itself out.
uh, I'm going to do a quick shameless plug because I've seen it play itself out. You do not want to have to deal with the IRS by yourself, which, Optima Tax and everybody else, but seriously, I'm not, we've talked about it in the past. I'm not trying to completely diss those services, but man, you really are going to save yourself a lot of headache if you have somebody by your side who actually has a bat line, like a good CPA firm that knows what they're doing by your side, because like you need to be able to sleep at night and not worry about, am I going to have guns drawn and badge wielding IRS agents coming down, or seizing my assets or whatever. Like that's just a ton of stress that's completely unnecessary. And the same thing goes true with lawyers. Have a good one. Just because they have a designation doesn't mean that they're good. Do your due diligence. It's worth it. It's worth it. And LegalZoom isn't necessarily always your friend. I mean, it might be in some cases. It depends. That's a good legal term, but and I learned it on the internet. But seriously, you need you need to save yourself. So, I had a question for you guys with regard to acquisitions, because we all are involved in those things. I want to go back to, if you're thinking of a merger, which I still completely think is a complete misnomer. Somebody bought somebody, somebody's culture is going to overtake. If you had a word of advice, like I want you to think of it as kind of a lightning round. You had a word of advice for somebody contemplating a merger with somebody else, or acquiring somebody else, what would be the number one piece of advice that you would give to your client or your good friend? So I'm going to start with you, Jack.
So if you're only allowing us one word, I'm going to hyphenate the
No,
word.
not
Okay.
not just one word, but one piece of advice. Like, hey, this would be the topic.
Okay. Well, we use one word and I'll expand. I would say open-mindedness, which is and it goes back to culture, and understand that, okay, we've been doing it this way for 20 years and we believe this is the best way to do it. And if we're the acquiring company and we're like, okay, we're going to assimilate, like the Borg, the culture, and make them part of our culture. And just understand that, okay, maybe the acquirer's culture may be the dominant culture in the way of doing things, but you're adopting another family that has been doing it their way for a period of time. If you don't want to adopt their culture, then don't merge, buy their assets, and just take their stuff and pull it into your culture. But when you're doing a true merger, you have to understand that is going to happen. And the other way around, if you're being acquired, understand that, it's in you deciding as a business owner to be acquired, you're conceding a lot. And need to consider that, which is, okay, it's likely going to be their way. And, to the extent that you can, um, I'm laughing because my kids told me, stop saying that, just say if. So if, instead of to the extent that you, you know, if there is an ability to maintain the culture, I mean, we don't see that often. If you have a parent company, maybe as an investor that is acquiring a business and they want it to remain intact and they like what you have going on, but if it is a true merger where you're bringing the culture into another culture, just keep that in mind, that that is something that you are inherently conceding to by being acquired. And sometimes that's hard to swallow because it's, hey, this is a family owned business. You promised us, acquirer, that you weren't going to impose your cold corporate culture and processes and procedures that we did just fine on ladies and gentlemen's arrangements, and now you want to formalize everything and have all these processes and procedures and create this regulatory regime within our company, right? And so that's what I would say. And which is probably not a shock to anyone on the phone, which is we talk a lot. I talk a lot about culture because that's beyond the economics and everything else. But that is a major consideration when you're joining two families together.
Oh, I love it. I love it. And it was a lunch with this guy that's part of this global company, and the crazy stuff that they have seen from it's a 130-year-old company, great, super solid culture. Then they had to do a carve out. And so private equity comes in. I'm like, oh boy. He goes, actually, this one was really good. They let us alone. They actually brought help but let us, be who we are. And then they went into a deal where another, 3 to 5 year hold, and it moves to Chainsaw Al reincarnated, and anybody, hey, so here's a gift card. Anybody know who Chainsaw Al is without having to Google? If so, Jack's got a card for you. So Adam, question goes back to you. What's the
Yeah.
one piece of advice beyond what Jack said, or maybe you can dovetail on it, but what would you say?
It's pretty similar, but slightly different wording, which is, rarely have I seen an acquisition fail financially. It's always culturally.
Mm-hmm.
And at the same time, you've only got like, I mean, it would, in other words, like, Jack, what's the number of times when you've been dealing with a transaction that a potential buyer and a seller agree that, hey, we're gonna allow, the buyer to really interview and spend quality time, like, months, with the key executive team, just evaluating whether or not there's be a cultural fit. Like, how many times, has that happened in your career?
I think I may have saw that in a drama on TV, but that's TV, right?
Yeah.
So
Yeah.
yeah,
So the reality is you're either not going to meet them, or at best, you're gonna it's gonna be like a day. It may be over a month, but it's gonna be a day. And so that's the kind of, it's like, you're making a multi-million-dollar decision on people that you're now gonna have to with less time than you have to interview an employee. and make that decision. So, accepting that, would I not do a transaction? No, that wouldn't be a reason not to do it. But what it does do is it forces you, our lesson learned, that we would advise a client in, is it forces you into like being extremely specific, but yet reasonable and fair in terms of what's expected from the standpoint of like, okay, on day one, we expect you to do A, you know, on day 30, we expect you to do A plus B, you know, on day 90, we expect you to do A plus B plus C, you know, and getting pretty quickly to like, you know, look, these people are either, you know, rowing with the team or not rowing with the team, you know, and you know, kind of moving pretty quickly to just figuring out how to root out, you know, passive aggressive or aggressive behavior. Like that should be expected in the first 30 to 60 days. But you know, when you kind of start getting to 90, you know, days, you know, 6 months, you can spend a lot of management attention devoted to trying to turn people around that are just not ever going to turn
Yeah.
around, you know? So, and it doesn't matter. It doesn't matter what you do, you know, like again, our experience, Gary, we won't use the words because I'm not swearing right now, that I was actually called on a Zoom meeting, you know,
Oh
by,
yeah.
yeah, like, I mean, you know, she didn't know the mic was on. I never even met this woman, you know, and like, it's legendary at BGW and still
It's
recorded.
legendary.
Yeah. And keep in mind that like with this particular group, you know, their benefits in effect, their salaries went up by like 15%, plus their benefits, like time off, all like the stuff, like all the stuff, Jack, it had doubled. You know?
Yeah.
So like we literally had done nothing to this woman but changed her password. You know, like in the grand scheme of things, you know. So that'd be my advice.
Yeah, it was legendary and it was on tape. It was on a Zoom meeting and it was the funniest thing. Like Adam, you were very gracious, but it caught him off guard. Like all the rest of us, like, yeah, Adam's hole is what is what, and it wasn't Adam's hole. That's what it was said with the entire company hearing it. And he was like, what was that?
Yeah, so I didn't hear that. Yeah. Surely you didn't just call me that.
Oh my gosh. Yeah, culture, 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 culture. Now, one thing that I will say, and I did see this when I was in this private equity firm when we were acquiring companies for our amalgamation to really behave like a multifamily office for these very high net worth people. We had a couple of, actually, our acquisitions were pretty good. However, as they got bigger, they became more important. So I actually learned from a group that does cultural compatibility assessments. That's all they do. And it's a 2-day management team offsite brought together, facilitated, where you get into the nuts and bolts of a 100-day plan by the time you're done. And then it's a thumbs up or thumbs down vote. And then I was brought in to do it for subsequent ones. So we did it, I think, 3 times. And it really helped us avoid disaster because all the finances looked good. The CEO was pressing really hard to get this deal done because he just was salivating at all the financial benefits. But the management team did a thumbs down on it. And it was a good thing. Now that company still went down during the downturn for a number of reasons, but it was a subprime lending thing that it had nothing to do with well-heeled families. But it's just he was chasing money. And so I would say that doing at least a 2-day offsite with the two management teams facilitated by somebody that knows what they're doing can really save a lot of heartache, because you're getting into, all right, so we got one seat for this role, but there are 2 people that currently occupy that role between these 2 companies. Who's going to get it? That is where the rubber meets the road, man. So yeah, I like that one. That was good. So Jack, I'm going back to you on Corporate Transparency Act. So we've talked a lot about it, especially early on. It's dying down a little bit, but the teeth are they're still there. The law is still there. Who knows if it's going to get repealed or not? But anything that you would say to anybody, like they're forming a new entity or they're forming a new or bringing on a new partner, any words of advice?
Yeah, so the the federal government, meaning the FTC, is continuing to act as if it's going to stand, meaning that there is an FAQ out there similar to their attempt, the IRS's attempt to, and the SBA's attempt to bring some chaos to the PPP program. The FTC is trying to bring some organization to the chaos of the Corporate Transparency Act. It's less chaos than it was under the PPP because of the urgency and people's stress levels and everything else. But however, the we are proceeding with and will shortly be contacting our clients that have businesses or entities in existence prior to January 1 of this year, and letting them know, as far as we know, that this is going to remain in effect and they need to have reported this by the end of this year. And so please send, the message will be, please send, if you want us to handle it, please send us the information that we need, which is basically the ownership information of your business. It gets a little more complex when you have stacking of businesses. So you have holding company, you may have foreign investors. And so how deep do you have to go? So what is happening is that these frequently asked questions, the responses are kind of focused on the nuances of who are the beneficial owners, who are the reporting personnel, who is required to do certain things. If this company only owns this much and it's indirect, are they still a beneficial owner? So there's interpretations that are going on, but for the most part, our most businesses are either able to do this on their own and file it. Some businesses don't want to do it because then they become the filing entity. They have to get their own number. They have to file for each entity. Whereas we are able to, through our portal, if an owner has 5 different entities that he or she needs to report on, we can put those all in at the same time and be done with it and get a report back. So and obviously I should say the ones that were formed after January 1st, 2024 should have been reported within 90 days. And if you haven't done that, then that's a different conversation that we need to have. But so yeah, we've been procrastinating a bit on getting to our clients, hoping that there might be some guidance as to, and there have been challenges, court challenges. The problem is when you have a court challenge, whatever happens. So if there's a temporary restraining order or preliminary injunction on the enforcement of something, it only applies to the people that filed the lawsuit until it is otherwise determined that that is going to be the law of the land, or there's other jurisdictions that are imposing that, other federal courts or appeals courts that are upholding the lower federal court, the district court decisions. So at this point, it is still the law of the land and we need to comply with it. And here we are mid-July. And we're running out of time to say, yeah, well, let's kick that can down the road, because we're getting down the road.
Yeah, and just to be clear, if you dutifully did your thing, whether there's a new entity and you're within the 90-day window, or it was pre-2024 and you've said, all right, I'm still going to go ahead and bite the bullet, you don't have to keep refiling unless you have change of ownership structure in that. So it won't, like, once it's there, but if you're adding new people or entities, it clicks back over, correct?
Yes, or subtracting. So you buy out a partner, or so there's a redemption, or that kind of, or sale. So yes, those count as well.
Okay,
Now
cool.
there are certain exemptions, but most of us will not fall under those exemptions.
So with a little bit of a precursor for next week, if we're still going to do this as a feature, Adam, but in effect, the theme will be how to avoid hiring a sales dud, not a dad, but a dud.
That's right. That's right.
So,
And not a stud, a dud.
not
Okay,
a
let's continue
stud,
the
a
pun.
dud.
Yep.
Think of 4th of July, you're all excited and you lit the fuse and nothing happened. Sales dud. I will not be here, so if you guys want to bag on me, you can. I'm going to be doing my 3rd day of getting qualified to speak at Vistage. So Dave Zerfas has me going through 3 days of back to back to back in Vistage's protocol. So that ought to be fun, but I will miss you guys. So, but we'll have a special guest next week. So you can tune in and you'll find out, and we'll let you know but ahead of time, but there will be a special guest that will help you guys not hire a sales dud. So as we're coming into the last 8 minutes of the time today, anything, Adam, that you would add?
No, I think we got it. Stuff to just be aware of. You can't rely on government regulation because the courts overturn. I mean, you still probably follow it, but I'm just saying that that some stuff could be getting overturned that have been long standing. Secondly, if you had some people that weren't making $59,000 a year that you were considered salary employees, you got to reevaluate what you're paying them. And third, yeah, you still need to report this crap. Not your company. Like it hadn't gone away. So
And
We
what
are
I
here
might,
to help you. Go ahead.
I would say what I might cover a little more next week is the kind of the status on this FTC, another FTC issue with the non-competes. It's still kind of early to chat about it because so briefly what happened was this is something, and I'm not going to share how I feel about it, but you may get the gist of it. But back in January of 2023, the FTC came up with some bonehead idea that maybe we shouldn't have non-competes be enforceable across the board, which includes inline, what I would call inline. So for employees that are working and you don't want them to steal your stuff and go work elsewhere and steal your clients and your employees, everything else, but also with respect to the purchase and sale of businesses. I'm more concerned about the second. I'm concerned about both, but the second because so many times the value in buying a business is the fact that you are benching the seller, and if you're not continuing on the relationship with them through an employment agreement or consulting agreement, you don't want them opening up a shop next door to you, and so there are certain impacts unknown how that is going to impact, but reading the letter of the law or the rule that was passed would have an impact on that. There are certain exemptions, but there's also requirements that the employee be notified. Hey, employee, you know that non-compete you signed 2 years ago? Well, today's your lucky day. You don't have to worry about it. You can quit whenever you want. You can go work next door, and so it's those kind of things. And in fact, my understanding is, and I didn't read all 570 pages of the rule that was published back in April this year, but my understanding is that instead of spending 2023 and part of 24 reducing the impact, they've expanded the impact of
Oh,
of the
wow.
rule. And so we can talk more about that, but a lot of questions have come up regarding that, more so in the context of buying and selling businesses, because now it's, well, I don't know if we should be paying that seller that amount of money if we want him benched, and if we're going to be told not benched. So what it's causing is paying out some of the purchase price down the road, or turning it into an earnout or a promissory note that says that if this is invalidated, then the promissory note is dissolved because we're not getting the value of the purchase price because of that. So again, I just threw a lot of stuff out there into the mixer.
Wow.
But yeah, we need to talk about that a little more.
Well, it does it does emphasize the fact of, all right, if you better have somebody by your side that knows what they're talking about, and there are ways to put teeth into stuff, but you can't assume that, oh well, the past teeth are going to still apply. Wow, that's a great point. All right, so well, next week ought to be pretty good. So don't be hiring any sales duds, and then, hey, what's this non-compete thing going to be? What are the impacts? So anyway, if anybody came on late, we'll put this up on the BGW CPA YouTube channel, and Shoemaker's going to do the same thing. And thank you guys for taking time. Adam and Jack, always good talking to you. And Jack, I'm going to give you a call because we've got a mutual client that we need to do something with in a good way. So
Okay.
I'll give you a call right next.
Excellent.
Thanks, guys. See y'all.
Thank
All
you.
right, see you
Bye.
guys. Bye.